We need to redefine what best practices is.
And to remove the that's the way it's always been done
Correct.
mentality.
We have to ask the judge for permission on everything and beg and plead as if we're children talking to our parent.
And not a lawyer who's been practicing for 30 years.
That has to change. That mindset has to be more of, we're in this together. This is a collaboration. I'm not your mom. I'm not your dad. You're not my petulant child. So we have to shift it where this is a collaborative approach. Yes, I'm the judge. And yes, I set the deadlines. And yes, you must defer to me. And of course, they've earned and deserved that respect. But this immediate knee-jerk reaction to adjournment requests, like, you're better than me, that has to go away.
All right. Welcome back to the Mighty Merp podcast. Today I'm joined by someone who has become a part of the Mighty Merp family, possibly the first time ever 3-time returning guest, Jeralyn Lawrence, founder and managing member of Lawrence Law, past president of the New Jersey State Bar Association, and leading advocate for attorney wellness. Building off our recent episode with Maritza Rodriguez on Putting Lawyers First initiative, Jeralyn joins us to discuss the progress made by the Supreme Court Wellness Committee, her recent CLE with the Acting Administrator Director of Courts, Judge Michael Blay, and the shared importance of wellness among lawyers and judges. Jeralyn, welcome back.
Thank you so much for having me. Wow, 3 times and I'm a record holder. I love that. That's exciting.
I think so. 3rd time's a charm. I will say we have someone coming back this season, which will also be a 3rd time appearer, but you win because you're first.
And I'm also from Wayne, where you're from, so.
Yeah, so definitely winning on that. So I'm going to just start off with, how does it feel that the legal community is finally giving wellness the attention it deserves? And kind of jumping off that it was, I'm going to say, you were pivotal and you spearheaded this initiative.
Well, thank you for that. It feels wonderful, to know that it has taken off to the extent that it has, and it's top of mind for lawyers, for leaders in the judiciary, leaders in the profession. I think the biggest hurdle was getting an acknowledgement that there's an issue. And I think the survey that Putting Lawyers First did made it very clear that there's an issue. The statistics confirmed what we all felt and knew in our own hearts. So getting that confirmation, I think, was critical. And then having the Supreme Court act and form the Supreme Court committee. Our new acting director, Judge Blee, is really just has been terrific. Wellness seems to be a passion of his as well. So it was really the culmination of a lot of good things happening, in conjunction with each other. But, it's, it really feels good. It feels good to have an idea, to use the presidency to have really started some tremendous work. I was surrounded by amazing people. You said you just had Maritza on. She's a force in the wellness field, just like yourself. So that's part of that's part of the success, is who you surround yourself with. And Putting Lawyers First was 40-something people, 44 people, I think, on the task force, 6 different subcommittees, everybody trying to offer concrete solutions as to how to solve the many issues that we have in our profession.
Okay, so I had 2 different questions popping in my head at the same time as you're talking. So I'm going to start with the Supreme Court Wellness Committee. How hard was that to launch? Did you think that it would be as receptive as it was by the courts? Sort of, what was the process of getting that established?
So every year, the Supreme Court invites the officers of the State Bar Association to Trenton, and we meet around a in a very gorgeous conference room around a very big table, and the president goes through what they would like to talk to the court about. And much of that conversation that year was the work of putting lawyers first. And we had a long list of initiatives that we wanted to talk to the court about, not only attorney wellness, but we talked about the character and fitness examination and removing a certain question from that application. I mean, there's so many things. We talked about our concerns in the ethics and fee arbitration processes, but the very
Mhm.
first thing we talked about, and the number one ask from the chief, was to form a committee. And on the spot, in that meeting, he said yes.
Wow.
Now,
Yeah.
I don't everyone has been gracious since and said, a lot of people have said it's because of putting lawyers first. I have never said that. I hope it was a big part of it. I think Judge Grant has given putting lawyers first credit. I think even Judge Blee has. And I'm sure the chief will as well, but I certainly don't want to say that it wasn't on the chief's mind. I think he is a very caring jurist. I think he cares about us. So he was probably hearing stories, and putting lawyers first is what hopefully pushed him over the edge. But I think he had it in his mind. But just in that meeting on the spot, he said yes and formed the committee.
So I'm going to talk about the committee in a few minutes and really the goals of the committee, what's been accomplished over the last few years, and what we can see moving ahead. But before I do that, I know you just had a CLE this past week where it was a conversation with Judge Michael Blee, who's the acting administrator of courts, who took over for Judge Grant. And I'd love to talk to you about that conversation. Um, but before I ask about the conversation, I'm always going to say, how did the discussion come about?
So, as part of the New Jersey State Bar Association, my presidency has ended and I'm off the board, but I still am one of the co-chairs of our lawyer well-being committee.
Hmm.
And so I just reached out to him and said, we put on these seminars. We had spoken together on a panel at the annual meeting in May. And I think he really enjoyed it. He was very passionate about it. And
Hmm.
so we asked him again. He's extremely busy. And it was really just an ask to please participate in a conversation with us about attorney wellness. And he was all for it. Um, I'm grateful that you were on. I mean, you've been a wonderful liaison for us and for him, since you're a Atlantic City girl, and I think he's one of your former PJs and assignment judge, and so you
Hmm.
have a long history of working with him. Um,
I actually think I handled his first criminal juvenile trial when he was a judge. I think I appeared in front of him for maybe his first plea in
wow.
when he moved to adult criminal courts. Um, and then he moved to Chancery. I did not appear in front of him at all there. But yes, we're a very small community. And I do know that one of the amazing things about Judge Blee is that if you ask, he is on board,
Yeah.
especially on something that he believes in. And I know he believes in attorney wellness. I know it's important to him.
Well, what makes him so special is that he's a lawyer's judge, and I think, and he's also his background is so broad and diverse.
Hmm.
He's been I think the PJ of Chancery. He's sat in criminal. He's sat in family. He's
Hmm.
been a presiding judge. He's been an assignment judge. So it's easy to talk to him because he's had that stress of finding clients, minding clients, representing clients, collecting from clients. You know,
Right, because not only all the courts that he sat in that you just said, he also was a private practitioner. He was in a small firm. He was also a solo practitioner. He was a municipal court judge. He was a municipal court prosecutor. He was a municipal court public defender. He did civil. He did, he was a true solo practitioner.
so
So,
he understands the day-to-day stress that we feel, right?
mhm,
How hard it is to get clients, how hard it is to keep clients happy, how hard it is to get clients to pay. You know, that in and of itself is a lot of work. And, then you're being a lawyer as well, and you have, somebody on the other side, a colleague, an adversary on the other side. So there's a lot to it, as you know, doing it yourself. And he knows it. And so now he's in
mhm,
a position of power, and really can put his mark on the judiciary. So that conversation with him, I've thought a lot about it since. I thought it was awesome. Um, I've gotten such great feedback about it. To me, the biggest takeaway, I think, was, one of our colleagues told a very unfortunate story about not having a case adjourned, having absolutely no trial certainty, the impact that had on her, the sudden and unfortunate passing of her mom, taking care of her dad, just a lot going on in a very seasoned, talented, solo small firm practitioner's life. And she shared with us, how difficult it was to get an adjournment, how expensive it was for her to line up her experts, something that resonated very soundly with Judge Blee, having lived that experience as a lawyer.
mhm.
And he said to the 100 people on the Zoom, "Here's my email." And he gave us his email. And he
And
said,
he said, yeah, yeah,
"Go
go
ahead."
ahead. I mean, it was like, without hesitation, he said, please send me an email. Please, please
Yeah.
explain in more detail everything that happened.
He wants to
And
know about that. And it wasn't, I didn't take it to get anyone in trouble. He did not appreciate the lack of humanity.
mhm,
He reiterated that, this is a job and we all need to be humane and kind and make sound decisions, and offered his email to anybody that had an issue. And, you know, that's a unique perspective. And, as we said on the call, on the Zoom, I hope he does not get a lot of emails. Um, but he may get some, but I think it made everybody feel so much better to know that that opportunity was available to them
right,
in a moment of crisis, and, you know, adjournments not happening and not being ready for trial, but pretending that they're ready for trial, and all of the consequences that that has on a lawyer. He wanted to hear about it. And what else? What more could you ask for?
right. And he didn't minimize it in any way. He didn't. And those stories, unfortunately, we heard one that was shared, which was horrific. It was, sort of roadblocks after roadblocks after roadblocks of just wanting a firm answer regarding the postponement. Um, but I think we all can share stories, not even our own, but what we hear from other people that have really caused the practicing of law to become, for some, unbearable or just too burdensome.
And as a result, negatively impacting our health and wellness. So much so, 164 lawyers answered a survey that they had suicidal ideations. And, you know, if that's not a wake up call, if that's not a red flag that this is a profession in crisis and something has to change, I don't know what is.
Right. I also thought what was really important about the conversation And I think that um, I don't know if it was so much highlighted in the putting lawyers first, but remembering that our judges are lawyers, but also that the stats with judges are just as high with regards to burnout, stress, drinking, suicidal ideation, and so forth.
Yeah, they have to be extremely stressed. Yeah, and think about what their life has been since the pandemic. You know, during my presidency and even before that for a bit, the number of judicial vacancies in this state was through the roof in
Hmm.
unprecedented amounts. And that doesn't mean that the work goes away. That just means you have less judges doing more work. And so,
Right.
we've heard judges talk about actually sleeping in bed with their motions. They just
Hmm.
they fall asleep reading they have so many motions, so much to read. So the work didn't go away. They just had less of their brothers and sisters on the bench to help them. So they have to be incredibly burnt out. There's some expectation out there that judges have to be on the bench from 8:30 to 4:30. Well, when are they writing decisions? When are they writing motion orders? I mean, if you're supposed to be on the bench, if your hours are supposed to be 8:30 to 4:30 and you're on the bench from 8:30 to 4:30, when are you doing that? So you're doing that on
Right.
your own
Or,
time.
right. Is the expectation that the weekends you're supposed to be working or on your vacation?
I mean, well, the math isn't mathing, so it must be, right? So that leads to burnout. So, and technology, while wonderful, um, it has fostered a culture of instant messaging. In the old days, you would write a letter, wait a couple days for it to reach your office, open the letter, send it to your client. I mean, it could take 2 weeks to respond to a letter. The
Hmm.
time you and I are doing this podcast, we're going to have 10, 20, 40 emails in our inbox that
Right.
somebody's going to want a response by the time we leave on a Friday for the weekend. So the
Right.
pace of this practice is just at a level right now that's just not sustainable. So we have to figure out how to slow the pace down, how to make it a little more manageable. And there needs to be a culture change. This system that uh, the never off culture, the best lawyer's the busiest lawyer. I'm going to work myself to the bone. Um, that has to change. And I think a lot of that starts with the court, how they view it. I mean, uh,
Right.
we have some best practices model that I'm not so sure it's best practices anymore.
I boldly said to the presiding judge in Atlantic, which I did say I would also boldly say to anyone else, including Judge Blake, which might go contrary to what best practices are. But we were dealing with the FO docket in our county, which is significantly backlogged. And the FO docket, for those who don't do any family law, is the contempt cases of violations of the domestic violence restraining orders and also any forfeiture motions for gun forfeitures. And we were actually wasn't the presiding, it was the assignment judge of Atlantic County. And I said, and she was asking really interesting questions and good questions about the backlog. And I did have to explain on forfeiture motions, there's no reason, like they should, if you hire an attorney, they're going to be tried because the worst that's going to happen is that the forfeiture is granted and my clients would lose their Second Amendment rights. So if they're hiring me, they want me to litigate the case. And we were talking about the numbers again. And I said, say this respectfully. I know there's a push on numbers and getting things completed in a very short amount of time or a certain amount of time. But I'm going to boldly say that quick doesn't mean just or fair. Some cases take longer, and they take longer for a lot of different reasons. Sometimes we need to get experts. Sometimes they're just not resolvable. Sometimes they have to wait for the divorce proceedings to go through before we can do um, forfeiture motions. I said, I think the timeline, I know, brazen of me, is arbitrary. It doesn't work for all the cases. Not every case can be decided, just like not every restraining order can be
Mhm.
decided within 30 days. And I think that timeline puts so much pressure on the court, not just the judges, but everyone in the court, the staff, the judges,
Yeah. And it's
you
just
know.
this artificial, made up belief that cases should be done within a year. Cases should be done when cases are ready to be done. That's when a
Right.
case should be done. And it, the clients know when the case is ready to be done. Lawyers doing their job know when the case is ready to be done. And forcing it to be done prematurely is not justice, and it's not serving anybody's best interest doing that. And so I just think we need to take a broader look, and redefine the time frame within which we call best practices.
Right. So in our vicinage, we are fortunate that for the most part, we are fully staffed with judges, having a hard time with the court staff, and you need people to be able to run the courtrooms. But our criminal court docket has doubled.
Hmm.
The numbers of processed cases. I think the list used to be around 250 and lower. They're now over 400. Some were up as high as 450. It's a lot of cases
That's a
for
lot.
one judge to be handling.
That's and to handle it right, and to handle it within a year, and all the pressures, you know, that they
Right.
have
And
in the
clients that are detained are quicker.
yeah.
That's the thing. So, um, so the Supreme Court committee, um, are we on 2 years now with the Supreme Court Wellness Committee?
So it was formed, uh my presidency ended May of 23, right? So it was formed in May of 2023,
Yeah. So we're on 2 plus
2
years.
plus years.
Um, do you want to share what you think some of the achievements and standout of those initiatives have been? And maybe talk about your hopes about moving forward?
Sure.
Let's
So
talk about the achievements first,
okay,
because I want to rephrase the second part of that question.
okay. Um, so some of the achievements, there's certainly a focus on providing a tremendous amount of seminars, continuing legal education opportunities to talk about wellness, mindfulness, practicing gratitude, um, finding balance. I mean, really, there's a lot of attention, being
Setting boundaries.
setting boundaries, caretaking roles. So I think across the board, we've done a great job in highlighting, focusing on, and providing a lot of wellness related seminars. Um, I think a great thing that came from the committee is statewide listening sessions. The
Mm,
committee, leadership in the committee traveled to different law schools across the state and gave notice to anyone in the legal profession. If you have a question, a concern, an idea, join us at a listening session. We have an open door policy and we want to hear from you. It's the first time in 30 years I'm aware of the judiciary traveling the state wanting to listen to lawyers and you know
right.
like
And I love the fact that the listening sessions um, were there were no actual judges sitting in there during the listening sessions, which I think really did matter for some of the attorneys to be able to feel free to convey some of their frustration without feeling like there would be backlash
right.
or, you know,
for
And
what was
he
being said.
yes,
Another
and I was gonna say I was there at one of the listening sessions and nobody it wasn't really it really was about all you said about all the pressures that we have of managing, you know, our clients, our court appearances, our caseload. And even when there were concerns about judges, I will say I don't think anyone mentioned names of anyone. I think it was really just about wanting a little bit of uniformity and consistency.
and just soliciting ideas. No, the question right now is what are we going to do about it? We don't need any more surveys. I know the ABA just did another one, and that's wonderful, but I, I don't think we need any more surveys. That's not the
We
question
know what we
anymore.
know.
We know what we know. The question is, what are we going to do about it? Another accomplishment, I think, of the committee, and I believe it was Judge Blee's idea, um, to have the assignment judges of every single vicinage speak in September at their opening court events of every year about wellness. To
Mhm.
me, the first, when I heard my assignment judge talk about it, even though I was on the committee and I knew it was happening and, we were part of the process, to be sitting at a, Somerset County bar event and have the assignment judge of Hunterdon, Somerset, and Warren County talk about putting lawyers first, talking about the statistics, talking about attorney wellness, talking about the listening sessions, talking about the court wanting to hear ideas about how they can address the profession and wellness. I mean, to me, it's probably a moment, I will never forget because it was I had never heard anything like it in 30 years. And I mean, I
Mhm.
hope now I hear about it every September, and I trust that we will. But to me, that was a monumental shift in thinking. To
Mhm.
have the top judge in every county talk about some vulnerability, try to eliminate the stigma, and talk about wellness. This just was not going to happen 5 years ago, 10. It just was not going to happen. It was attorney wellness, toughen up. You went to law school. You knew it was a hard job. You're being paid well. You know, suck it up, girl. Right? I mean, that would
Right.
have been, I think, what people were told. So I loved that idea, and I think that that's been monumental. Um, I think the committee has tried to focus and highlight NJ the New Jersey Lawyers
Mhm.
Assistance Program, and what's available there. I think it's tried to highlight um, the State Bar Association, their member benefit. Anyone that's a member of the New Jersey State Bar Association and lives in their household is entitled to free counseling, at least 3 in-person sessions, unlimited phone and email. That's been
Mhm.
a tremendous member benefit. I mean, there's been phone calls and cases opened in the thousands.
Mhm.
NJ Lap is a wonderful resource, but that's what it is. It's a resource. It provides you with resources. What the State Bar member benefit does, it's the Charles Nectam and Associates CNA. They are actual therapists that you're matched with. That's your resource. That's your one-stop shopping. You get to get somebody, right on the phone. And um, I know there was a suicide in Hudson County shortly after my presidency concluded, and um, many members of the law firm where that gentleman practiced took advantage of that member benefit. And you know, I I think it was so incredibly important to have that support available. So, and I think that the Supreme Court Committee is doing a great job trying to get the word out about NJLAP and the CNA program so that lawyers and legal professionals know that these resources are available to them.
Yeah. So my follow-up question, and is really where do we go from here? Or what are our big goals? And let me say it like this. I'm going to tell you two different thoughts that I have and I've been thinking about a lot. I've had people come up to me and say, I've gone to all the CLEs. I get the journaling and the drinking of the water
Mhm.
and the taking the walks and the exercising and all those things that really do help mental health, the
Mhm.
breathing. And I'm not minimizing them at all. And I think they're essential and the conversation is essential.
But it's not
But
enough.
people, it's not, and people are saying,
Mhm.
but what's going to change? So, what's going to change is my question. Where do we go from here? And I want you to think of it in goals. And I'm going to give you the example. When you run a marathon or a half marathon, but I'm going to use the marathon. When I ran my last marathon and I was setting goals, I was told that I need three goals of the day. One is the third goal is going to be finishing the marathon. I've run a marathon before. I never ran New York. I was injured. The third goal is finishing the marathon. Okay. But the first goal is what is your dream perfect, movie ending of this marathon? So I'm going to, so that's the first. What's our like end goal? We want it all. We're asking for it all and we're going to be able to get it all. And the second is what maybe is what what everyone's going to agree on, maybe compromising. And the third is sort of where do we move from here that is making some difference, but will be the first step in maybe the marathon, right?
Mhm. So the hit it out of the park goal,
Home run,
the
grand
home
slam.
run grand slam, um, is really making headway into the culture change, into this patriarchal system that is the current state of the judiciary. I mean, I think we need to redefine what best practices is. I think we
Kind
need
of remove that's the way it's always been done
correct.
mentality.
And, you know, I don't know why the judiciary is set up where it's like lawyers. I understand judges are elevated from a lawyer. I understand that you've been elevated to the bench. But the system where, we have to ask the judge for permission on everything and beg and plead as if we're children talking to our parent. That
And not a
has
lawyer who's been practicing for 30 years.
right. That has to change. That mindset has to be more of we're in this together. This is a collaboration. And I'm not your mom. I'm not your dad. You're not my petulant child. So we have to shift it where this is a collaborative approach. Yes, I'm the judge. And yes, I set the deadlines. And yes, you must defer to me. I understand that. And of course, they've earned and deserved that respect. But this immediate knee-jerk reaction to adjournment requests, like, you're better than me, that has to go away. And I think what drives that is this best practices 1 year deadline, arbitrary, artificial nonsense that makes judges think they can't say yes to adjournments because some bean counter is saying, oh, your case is now 375 days old.
But you do know that a lot of times it's not the judges that are saying no. It so it can be their team leader, it can be their navigator, where the judge has said, my blanket policy is no adjournments. And so the judge isn't even seeing the letters of
That's a
the reason.
problem.
Yes, I agree
That
with
can't
you. I'm
happen
just,
anywhere. So
I,
that would be my number one thing, that could never happen,
I
right?
know,
I mean,
but I know that it occurs because I've had no requests, and then when I reach out and go call the secretary and say, "May I please speak to the judge?" And thankfully, I have a good enough relationship that the judge picks up the call, and I say, "I don't understand why my continuance was denied." And they say, "I didn't see your continuance." Or I go to court because I wasn't given a continuance because my mom was getting out of the hospital and I didn't give them enough notice because I didn't know. And then the judge is like, "I didn't see the request."
It's crazy. I mean, so the
It's
standard
crazy.
should really be once it every adjournment should be granted until it gets to a level of absurdity. We got to
Hmm.
craft it a little bit better than that. But I don't understand how, if a lawyer's asking for an adjournment, and particularly if it's consented to, how they even have a hard time. So I think that would go a long way. Lawyers not having to fight with the court, fight with court staff, fight with anybody about a simple request for an adjournment.
Right. So I know what your answer is going to be, but I'm going to ask the question because this is the pushback. Well, there's attorneys that are going to take advantage of that, Jeralyn.
That's 1 out of 100. How about we legislate to the 99 and don't legislate
Hmm.
to the 1, right? Bad cases make bad law. Bad lawyer, there's good and bad in every profession. I get that. And unfortunately, there are not 100% great lawyers. And there are people that will be offenders of this and will take advantage. But that's not who should be driving policy. That's
Hmm.
not who we should be legislating to. So if there's a bad actor that's abusing the process, never prepared, always wants an adjournment to an absurd amount of times, then you hold that one lawyer accountable. But why set rules for 99 other lawyers because one is taking advantage? And that's why we have best practices, because a couple bad apples ruined it for the rest of us. And now this is why we end up suicidal, wanting to leave the profession, depressed, drinking, abusing drugs, because you've put us on an arbitrary and artificial leash that's just not necessary.
Hmm.
So I get it. There are absolutely going to be people that push the envelope, but hold them accountable. Why hold you accountable? Why hold me accountable? I do what I'm supposed to do. You do what you're supposed to do.
Hmm.
Most everyone we know does what they're supposed to do. So why are
Right.
we legislating to the bad apples? That to me, that is so much part of this culture shift,
Hmm.
because that's how we have the system we have right now. This,
Right.
legislate. I'm the dad. You're the petulant child, and I'm going to tell you what to do. Um,
Right. And then there's a problem with the idea that it's the way it's always been, and which makes it okay. And nothing frustrates me more than hearing that as an explanation. Why is that the way?
yeah,
Because that's how it's been.
yeah. Well,
It
if it
doesn't
doesn't
mean
make sense, let's change it.
right. So changing the culture, which might be the hardest um
It's going to be like moving a battleship, but you got to start somewhere.
right. I think I've said it before about um the new generation, Gen Z, coming up. And I'm going to tell you that I really think that they're going to be able to move it faster and better because the things I am concerned about young lawyers generally, but the one thing that gives me hope is that they're not ashamed or concerned to talk about their struggles or their mental health. And I know people think that that's weak, and I don't agree with that. I think it's sort of really being able to set a boundary at a young age that I know I was not able to. And I think that
They're just not going to
I
tolerate what we were forced to tolerate. And
correct.
kudos to them, right?
Yeah, I hope the way we raise them is
That's right.
why they're not going to tolerate it.
And they shouldn't, because it's not okay, right? So it's just not okay, because because we had to suffer through it. I mean, that's what you want, right? That's what you want for your kids. That's what we're going to want for our colleagues that come after us. You're going to want to leave the profession in a better place. And
Right.
if we've opened some doors and hopefully empowered them to use their voice in a professional, constructive, responsible way to say, it's not okay that I have to work every weekend of the month because you have failed to manage your calendar properly, Mr. Senior Partner, Mrs. Senior Partner. You and I were raised, we were never allowed to say that.
Oh
I
my
think
God,
the
no.
lawyers coming up now, they're going to say that. And I don't think that's a
Mhm.
sign of weakness. I think that's a sign of strength, of balance, of boundaries, and fairness. They'll say, "Look, I'll get my work done. You may have to just be fair with me." And everyone understands emergencies happen, and you may need all hands on deck. But it's not an emergency every weekend for months at a time.
No.
So,
No.
and I agree with you. I don't think they're going to tolerate that kind of life. I don't think they are. Some other goals are, we've talked about um, ways to try to slow the pace of the profession. Um, trying to talk to the powers that be about implementing something called writing periods into the court system. The Supreme Court has it. If you pull up their calendar, they have periods in their calendar where they're hearing oral argument. And then they have periods in their calendar where they're scheduled to write. And by no means am I elevating all of us to the level of the Supreme Court, but I do want to borrow from some of their brilliance, and I think we should. I think they are brilliant in the sense that they say, let me manage my calendar let me be present and available and 100% focused on oral arguments. And then let me manage my calendar and block out time to write my opinion after processing those arguments. Well, we don't have that in the trial court. We don't have that in the appellate division. And as a result, trickling down to us, we have courts that want to have you in court all day, but then still want you to file a motion by a certain time, on a
Right.
Thursday. Well, something's got to give. So perhaps if we afforded the appellate division and the trial courts the same kind of thinking and gave judges, trial court and appellate division judges, some breaks throughout the year to just
Right. Writing
write.
periods
Writing
for
period
them, which then
means writing
allows the
periods for us.
lawyers. Yeah. So I'm gonna tell you that I think you'll know the stat. How what's the stats of solo practitioners in New Jersey?
Uh,
Do you know the percentage?
I I used to know it off the top of my head. I think it's more than 50%, but
Right.
I think
So
it's more than
I was
50%.
a small firm. I was a solo practitioner, then I was a small firm. I'm back to being a solo practitioner. I'm in court every day and I have lots of briefs that need to be written. And if I will tell you, I have a pile. Can you see it? Which side is it on? I
No.
think you can't see it, but I have a pile of briefs that um, I'm going to be writing this weekend. And I do try to set boundaries, but that I'm not working every weekend,
Mhm.
but I'm working part of a day every weekend. And it's really hard as a solo from a practical standpoint. If you're in court every day and
Mhm.
then meeting with clients every day, because you have
It's
to meet
very
with
hard
clients,
it's very
yeah,
hard for a solo, but it's very hard for lawyers, whether you're
yeah,
not a solo, because it's just mathematically doesn't jive. You can't be on your feet in court all day from 8:30 to 4:30 and be writing a brief between 8:30
right.
and 4:30, right?
Yeah, I think the writing session is a really good example of culture change that will benefit the courts and will benefit lawyers and will also change the culture.
Well, I hope we can get it passed. I don't know. We're gonna try. I think some of the people think that the public won't appreciate that. They'll think, lawyers and judges are taking time off, and I disagree with that narrative.
Have you had, cases that you haven't received a decision
Yes.
on by a judge? And I'm not saying the judges aren't working hard, but because of their workload
Mhm.
and caseload, they haven't been able to get their write their decision and then give it to the parties. So they're also backlogged. So as much as I guess the push can be that they're not working, but they are working. And
Right.
I know lots of people that, um, I have clients in custody. When I file motions and litigate motions, and then the judge says I need to reserve on this, I'll have my opinion written by this date. And then it's not written by that date. My clients are still sitting in custody.
Yeah.
So they would be happy for a writing period
You
for a
would
court
think
to
it
get it
you would
done.
think having that opportunity would serve the public better than the current system, right?
Right.
So,
I
and then another thing we've been talking about, and it's not new. North Carolina and 10 other states have some variation of it, a temporary leave policy, where
Mhm.
you're not going on disability status, you're not tapping out of the practice. You still have a practice there to run, you still have a firm, you still have payroll to worry about, and employees to worry about, and you can still take new clients and service clients, but you know, um, you may have a loved one have some kind of medical issue, and you need to be in the hospital with them during the day, and you can't uh, attend to a court appearance, or there can be a host of reasons as to why you may just need a temporary break. Um,
right. And when you say temporary, um, are you talking about a week? Are you talking about 6 months? And that might be part of the kind of concerns that when people hear temporary
yeah, I think
sort of
6
have
months
that.
is too long, and I think a week is too short. So I think
Me
we
too.
were around about a month, something
Yeah.
like that. Um, you know, the Eh, s I think that ballpark, 2 weeks feels too short, 5 months feels too long, 3 weeks feels too short, 4 months
Yeah.
feels too
I
long.
I and I think it's a really good example though of what the temporary leave is for. I lost my mom about a year and a half ago and I was her caregiver and 1 week wasn't enough. It just wasn't. Um,
Even 2 weeks wasn't enough, right?
you know, um, I think I took 2 weeks and I was fortunate enough that I was able to contact the presiding judge
Mhm.
of my main vicinage and the assignment judge, and they really took care of my calendar. But the goal is that it will be available for everyone
Mhm.
who has that emergency. And then sometimes if you have a, family member who's going through a illness and you need to be in the hospital and you need to have medical appointments, maybe it might be 30 days or 45 days, but I I don't think 30 to even up to 60 days is
Yeah,
unreasonable.
we were thinking 30.
I know. But I'm gonna just keep pushing.
Yeah. Look, the more people that push and the more conversations like this that we have, the better. There's just common themes. We gotta change the culture, legislate to the majority, not the minority. Bad cases make bad law. Um, and push. Uh, People may need to just take a short break. Just get their house in order for a moment. But again, they don't want to go on inactive status.
Right.
That has significant consequences to your practice and ability to practice law and service clients. But you may need a break from court events to tend to your own mental health, your child's, your husband's, your loved ones, and there should be a process, and it's almost astonishing because North Carolina, I think, has been in place for 20 years.
Right.
It's almost astonishing that New Jersey has none, and that we've been
Right. And
talking about it now for 2 years and still can't get it any legs.
right. And there's other states that have almost like the ability to put your not available for court on a calendar that everyone has in the state, and states that are significantly larger than New
Mhm.
Jersey, you know? So, um, it is interesting. So, um, so are those your like big goals versus little goals?
Those are my big
They're
goals.
all
No,
goals.
they're all goals, however they come, and, they're all the goals. Those are big and little, and I think, and invite your listeners or watchers, any ideas are welcome. We're not saying
That's the
we
other thing I love about this committee,
Mhm.
right?
Yeah, I mean, we're not saying we have all the answers. All we know, we're lawyers. I'm a divorce lawyer. I'm not a wellness expert. I'm not I haven't taken a wellness class in my entire life. I can get you divorced though, but I just know there's a problem, and there's a problem, and
Yeah,
where we really need the collaboration and the brainstorming and copying other states or coming up with our own ideas is how do we solve it? And there's
right.
not a one size fits all. So if someone out there has a better idea than what you and I have discussed today, we're all ears.
No, and I love that about the committee. I've been even had people reach out to me, and I will give them other individuals to reach out to because it's not a closed group. I think that everyone's so receptive to different ideas to bring to the table. Excuse me, I'm going to drink from my big water jug.
and drink from your water jug. And look, there's a lot of competing interests. The court doesn't want the court to be run like, a kumbaya session and, show up when you want and no, they want to run a tight ship and we get that. So, you're trying to come to a compromise, a collaboration with a lot of different stakeholders that have different goals. But it's a forum of dialogue. It's a forum for communication, for cooperation, for compromise, and but effectuating change is very, very hard. And it's exactly what you said. People are used to doing things the way they do it, and change is hard. But just because you did it that way doesn't make it the way. So when you find a better way, let's do it the better way. And that's our goal.
Yeah, and I do believe that if we can present a better way, I think that we have people like Judge Blee that will listen.
Well, look, the slide he presented during his presentation this week on that temporary disability slide, I think I had never
Mhm.
seen that slide. No one had, we have not talked about that. So it's something that internally, they're talking about with, Judge Blee and his team. So that was exciting to see, exciting to hear. We'll see how that develops with our next committee meeting. Um, but that wasn't happening 5 years ago. You know,
No, I don't think it was happening 2 years
no,
ago,
I don't
so
think so. So,
so I wanna thank you so much for your time. I really do appreciate the conversations because, I believe in this issue, from the bottom of my heart, not just for lawyers, for judges, in our community that I live in and Judge Blee lives in. We've seen a lot of people, a lot of lawyers, and also a lot of other professionals struggling with mental health. So it is something very important to me, which is why I've spent my first two podcasts of this season on
yeah.
the Wellness Committee. Um, Before I let you go, I'm going to just ask you if you want to share anything that's bringing you joy or happiness or hope right now.
Well, I want to share that I appreciate you. And I really think that you are a gift to the profession, and your passion for wellness and sharing some of your vulnerable stories, I think, has impacted the profession in such a positive way. So I really just want to make sure I say that to you.
Oh, thank
Yeah,
you.
and I think you've been, a wonderful friend and a wonderful ally and somebody that I enjoy talking to about this and brainstorming with. I don't know. I try to find a lot of try to find a lot of joy. My kids are doing great. a lot of people are getting divorced, unfortunate for them, but good for me. My husband's battling a significant health issue, and he's doing great with immunotherapy. So there's a lot to be grateful for. And my
It's a
parents.
good mom too to be grateful.
But yeah, it's a great, I'm looking forward to the holidays and my daughter being home from college, my parents. And so
Your parents look great. I see them online and I'm like, wow,
I know I'm
still
very,
going strong.
I count my lucky stars. So, on a daily basis, there's so much coming at us that, can knock you off your feet. But Judge Salas, Esther Salas, who I adore, she says you actively have to choose joy. And so I try to follow her lead, and instead of being a grouchy, old, or miserable person,
Well,
try to
I'm not
choose
as
joy.
wise as Judge Salas, but I tell my kids, and I say it, that you have to find the silver lining in everything. There is always a silver lining. And I think when you find it, then you see the joy in
Yeah.
that situation,
So that's all I got
Might
for
be
you,
corny.
sister. It's but corny, but true.
Yeah. Thank you.
Thank you for having me again.
3 times.
3. I love it.
All right.
One of the best ways to support Melissa and the Mighty Merp podcast is to go to our YouTube page, find the subscribe button, open the menu, and click the bell icon so you actually get alerts when we post new episodes or shorts. For any questions or interest in podcasting, go to legalpodcasting.com.